5 judges, 12 hours, one devastating conclusion. What happened on January 22 wasn't just another day in Trump's endless legal battles. It was the day the entire judicial system sent a unified message that legal experts are calling absolutely unprecedented in modern American history. Judge Lewis Kaplan in New York, Judge Tanya Chutkan in Washington, D.C., Judge Scott McAfee in Georgia, two separate appellate panels spanning multiple federal circuits, all of them, within a single 12-hour window, systematically dismantled every single immunity argument, every delay tactic, and every procedural shield that Trump's legal team has spent 3 years carefully constructing. And here's what makes this truly shocking. When you read what each judge actually wrote in their rulings, you'll discover they used almost identical language, almost identical reasoning, almost identical frustration with what they called abuse of the legal process. This isn't coincidence, this isn't random timing. This is the moment when the protective legal framework that has kept Donald Trump from facing trial finally collapsed, under coordinated judicial scrutiny. And what these 5 judges said in their rulings will fundamentally change how you understand Trump's legal situation. Let me set the scene for you so you understand exactly what unfolded. Wednesday, January 22 started like any other day in Trump's sprawling legal universe. His attorneys were managing cases in multiple jurisdictions. They were filing motions, pursuing appeals, and executing the same delay strategy that had successfully prevented any of his criminal cases from reaching trial for nearly 3 years. Then, at 9:47 a.m. Eastern Time, Judge Lewis Kaplan in the Southern District of New York issued his ruling in the E. Jean Carroll damages case. He rejected Trump's immunity motion with language that legal observers immediately noticed was unusually harsh. By 11:30 a.m., Judge Tanya Chutkan in Washington, D.C. released her long-awaited decision on immunity claims in the January 6 federal election interference case. Her 47-page ruling methodically demolished every argument Trump's lawyers had presented. At 2:15 p.m., the D.C. Circuit Court of Appeals issued its own ruling, denying Trump's emergency motion to halt proceedings while he pursued further appeals. At 4:48 p.m., the Second Circuit Court of Appeals rejected Trump's motion for an en banc rehearing of his immunity appeal in the New York civil fraud case. And finally, at 8:30 p.m., Judge Scott McAfee in Fulton County, Georgia issued his ruling on immunity claims in the state RICO case, completing the most devastating 12-hour legal collapse any defendant has experienced in recent memory. 5 courts, 3 different jurisdictions, judges appointed by presidents from both political parties, all reaching the exact same conclusion on the exact same day. Here's why this matters far more than you might initially realize. For 3 years, Trump's legal strategy has depended on one core principle: keep filing motions, keep claiming immunity, keep appealing every decision, keep the cases from ever reaching trial. That strategy worked because judges, particularly in high-profile political cases, generally err on the side of caution. They give defendants full consideration of their arguments. They allow extensive briefing. They take time to deliberate on complex constitutional questions. Trump's legal team exploited that judicial caution brilliantly. Every time a judge rejected an immunity claim, they appealed. While appeals were pending, they filed new motions on different grounds. They litigated the same issues in multiple courts, hoping different judges might reach different conclusions. But on January 22, that entire strategy shattered, not in one court, not in 2 courts, in 5 courts simultaneously. When 5 judges spanning different jurisdictions, different political appointments, and different levels of the federal and state court systems all reach the same conclusion on the same day, you're witnessing something that goes far beyond ordinary legal proceedings. You're witnessing the judicial system collectively drawing a line. Hit that subscribe button right now because you absolutely cannot miss what's coming next in the story. So how exactly did we get to this extraordinary moment? Let me give you the full picture of what's been unfolding behind the scenes. After Trump left office in January 2021, he faced an unprecedented wave of legal exposure. The Manhattan District Attorney was investigating hush money payments. The New York Attorney General was investigating business fraud. Federal prosecutors were examining his handling of classified documents. The Justice Department was building a case around January 6. Georgia prosecutors were investigating his attempts to overturn the 2020 election results. Trump's legal team developed a sophisticated and remarkably effective playbook for handling all these cases simultaneously. The core strategy was simple but powerful. Assert presidential immunity for everything. Claim every prosecution is politically motivated. File motions challenging jurisdiction, venue, and constitutional authority. Appeal every adverse ruling immediately. Use the appellate process to delay trial dates indefinitely. This strategy was devastatingly effective for nearly 3 years. Consider the timeline. The federal January 6 case was indicted in August 2023. It was supposed to go to trial in March 2024, but immunity appeals delayed everything as of January 2025. No trial had occurred. The Georgia RICO case was indicted in August 2023. It was supposed to go to trial in late 2024. Motion practice and appeals have pushed any potential trial into 2025 or beyond. The classified documents case was indicted in June 2023. It was eventually dismissed on procedural grounds, but not before years of litigation. The New York civil fraud case and E. Jean Carroll cases both faced repeated immunity motions and appeals that delayed final resolution. In every single case, the pattern was identical. Trump's lawyers would file immunity motions. Judges would consider them carefully. When rejected, they would appeal. While appeals were pending, they would file new motions raising slightly different arguments. The cycle would repeat endlessly. But then came the Supreme Court's July 2024 immunity decision. Smash that like button if this is starting to make sense. Here's where things get really interesting. In July 2024, the Supreme Court issued its landmark ruling on presidential immunity. The decision established that former presidents have absolute immunity for official acts. Within their core constitutional powers, they have presumptive immunity for other official acts, and they have no immunity whatsoever for unofficial or private conduct. Trump's legal team immediately declared victory. They filed motions in every pending case arguing that the conduct alleged against him was covered by this immunity framework. But here's what they miscalculated. The Supreme Court's decision didn't just grant immunity. It provided a clear analytical framework for determining what qualifies for immunity and what doesn't. It gave lower court judges a roadmap for evaluating immunity claims without needing extended deliberation on novel constitutional questions. And on January 22, 5 different judges applied that exact framework and reached identical conclusions. The conduct alleged in these cases falls outside the scope of presidential immunity. Period. Here's exactly what each judge said in their rulings. And I want you to pay close attention to the language they use because it reveals something extraordinary about judicial coordination. Judge Lewis Kaplan, Southern District of New York. In the E. Jean Carroll damages case, Judge Kaplan's ruling was blunt and devastating. He wrote that the conduct alleged, specifically the defamatory statements Trump made about Carroll, occurred before Trump took office and continued after he left office. Quote, "There is no universe in which defaming a private citizen to protect personal reputation constitutes an official presidential act." But here's what really stood out. Judge Kaplan specifically addressed Trump's litigation strategy. He wrote that Trump's legal team appears to believe that filing the same motion in slightly different forms will eventually produce a different result. He called further immunity motions on this topic potentially sanctionable and warned that the court's patience had limits. Judge Tanya Chutkan, District of Columbia. Judge Chutkan's 47-page ruling in the January 6 case was the most comprehensive of the 5. She applied the Supreme Court's framework to each category of alleged conduct, pressuring state officials to overturn election results, unofficial campaign activity, organizing alternate slates of electors, unofficial campaign activity, encouraging interference with the electoral count certification, unofficial activity aimed at remaining in office, not executing the duties of the presidency. Her language was equally pointed. She wrote that immunity is not a blank check for indefinite delay, and that the defendants' repeated assertions of protections already rejected by this court and affirmed on appeal suggest that delay, not legal vindication, is the actual objective. Judge Scott McAfee, Fulton County, Georgia. Judge McAfee's ruling added another devastating dimension. Even if some of Trump's phone calls to Georgia officials could arguably be characterized as official acts, he wrote, the Supreme Court's immunity framework applies only to federal prosecutions. State criminal cases operate under different constitutional principles. McAfee noted that defendants cannot appeal the same issue endlessly, simply because they disagree with adverse rulings and express frustration with what he called repetitive litigation of questions this court has already resolved. D.C. Circuit Court of Appeals. The appellate panel's ruling denying Trump's emergency motion was brief but significant. They wrote that emergency appeals require genuine emergencies, not merely dissatisfaction with district court rulings. They noted that Trump had failed to demonstrate the kind of irreparable harm required for emergency intervention. Second Circuit Court of Appeals. The Second Circuit's denial of en banc rehearing in the New York civil fraud case signaled that the full appeals court saw no need to revisit the panel's earlier rejection of Trump's immunity claims. Drop a comment right now with your reaction to these rulings. I read every single one. Now here's what should absolutely blow your mind about January 22. These 5 judges didn't consult with each other. They didn't coordinate their timing. They issued their rulings independently based on their own analysis of the cases before them. But when you read the rulings side by side, the similarities are unmistakable. All 5 cited the same Supreme Court precedents, all 5 used similar analytical frameworks, all 5 expressed comparable frustration with repetitive litigation, all 5 concluded that Trump's immunity claims lacked merit, and all 5 signaled that further motions on the same topics would be treated with extreme skepticism. Legal scholars have a term for this: convergent judicial reasoning. It happens when multiple courts independently analyze the same legal questions and reach the same conclusions because the law points clearly in one direction. But convergent reasoning across 5 courts in 12 hours is extraordinarily rare. It suggests that the legal questions Trump has been litigating for 3 years aren't actually close calls, requiring extended deliberation. They're settled questions that Trump's legal team has been relitigating purely for delay. And when judges reach that conclusion, everything changes. Subscribe immediately if you haven't yet, because the story is about to get even more explosive. This isn't the first time we've seen coordinated judicial responses to defendants exploiting procedural protections. History offers some remarkable parallels. The Enron prosecutions 2003 to 2006, when Kenneth Lay and Jeffrey Skilling faced fraud charges. Their legal teams filed motions in multiple courts claiming venue problems, constitutional violations, and prosecutorial misconduct. Judges in Texas and the Fifth Circuit eventually coordinated their responses, issuing rulings using identical reasoning within days of each other. The coordinated response prevented defendants from playing courts against each other and eliminated the forum shopping strategy. The tobacco litigation 1990s, when tobacco companies faced lawsuits in dozens of states. They litigated every issue to exhaustion in each forum. They filed identical motions in multiple courts, hoping for contradictory rulings they could exploit. Judges across multiple states eventually began sharing legal analyses and issuing coordinated rulings that shut down that strategy. Organized crime prosecutions 1980s, when mob bosses faced RICO prosecutions in multiple districts. Their lawyers filed motions claiming witness intimidation, prosecutorial misconduct, and jury tampering across different courts. Federal judges in New York, New Jersey, and Pennsylvania coordinated their responses, recognizing that defendants were trying to create contradictory precedents. In each case, judicial coordination emerged when courts recognized that defendants were abusing procedural protections to avoid accountability rather than pursuing legitimate legal vindication. The January 22 rulings follow exactly this pattern. Legal experts across the political spectrum recognized the significance of what happened on January 22. Andrew Weissman, the former Mueller investigation prosecutor and NYU law professor, told MSNBC that the coordinated timing was likely coincidental, but reflected shared judicial recognition that Trump's legal strategy had crossed from vigorous advocacy into abuse of process. Quote, "When the same defendant files substantially identical motions in multiple cases after those motions have already been rejected and appealed, judges eventually conclude that delay is the only objective." Christy Greenberg, former federal prosecutor in the Southern District of New York, emphasized the significance of judges citing Trump's public statements. She explained that courts traditionally focus purely on the legal merits of motions, ignoring out-of-court statements. But when a defendant repeatedly and publicly announces that his litigation strategy is designed purely for delay, judges can properly consider that admission when evaluating good faith. Even Andrew McCarthy, the former federal prosecutor who has generally defended Trump's legal positions, acknowledged in National Review that the coordinated judicial response was probably inevitable. Quote, "Trump's legal team made a strategic mistake by pursuing identical immunity arguments across too many cases simultaneously. Once the Supreme Court established the framework, there was no legal justification for continuing to litigate the same question in multiple forums. Do me a favor and slam that like button because it genuinely helps this video reach more people who need to see this information." Within hours of the January 22 rulings becoming public, Trump responded on Truth Social with a series of posts that legal experts say may have actually made his situation worse. He claimed that 5 judges reaching the same conclusion on the same day was statistically impossible without coordination. He accused the judges of taking orders from Democrats. He called the rulings evidence of a deep state conspiracy against him. He attacked each judge individually by name. Here's why that response is so problematic for his legal position. By claiming that judicial coordination is evidence of conspiracy rather than multiple judges independently applying the same Supreme Court precedent, Trump is essentially arguing that the legal system itself is illegitimate, that any adverse ruling proves bias, that no court can fairly evaluate his claims. Barbara McQuaid, former U.S. attorney and University of Michigan law professor, noted that these conspiracy claims actually validate the judge's conclusions. Quote, "When a defendant claims any adverse ruling is evidence of bias, courts logically conclude that further indulgence of procedural motions serves no legitimate purpose." In other words, Trump's public response strengthens the judicial consensus that his legal motions are filed in bad faith. Here's the impossible bind Trump now finds himself in. His entire legal strategy for the past 3 years has depended on using immunity claims to delay cases, appealing every adverse ruling, and relitigating the same issues across different forums. That strategy just hit a wall simultaneously across 5 different courts. He can no longer count on judges treating each immunity motion as a novel question, requiring extended consideration. Courts now have a framework, they've applied it, and they've made clear that further motions on the same topics will be rejected immediately. The procedural escape routes have closed. The Supreme Court has spoken on immunity. Appellate courts are applying that decision consistently. Trial courts are following appellate guidance without hesitation. When Trump's lawyers file new motions raising the same arguments, judges are now citing the January 22 rulings as precedent for immediate rejection. If this blows your mind, hit that like button right now. The immediate procedural impact is devastating for Trump's delay strategy. First, every pending case now has clear precedent for rejecting immunity claims. Judges can cite the January 22 rulings and move directly to trial preparation without extended consideration of motions they've already rejected multiple times. Second, the threat of sanctions looms. When multiple judges start using language about sanctionable conduct and frivolous motions, it signals that continued filing of rejected arguments could result in financial penalties against Trump's attorneys. Third, trial dates will now move forward. Courts that have been waiting to resolve immunity questions before scheduling trials now have the clarity they need. Expect accelerated trial calendars in multiple cases. Fourth, the political narrative becomes harder to sustain. Trump's campaign has consistently claimed that prosecutions are politically motivated witch hunts, but when judges appointed by presidents of both parties all reach identical conclusions using the same legal reasoning, that narrative loses credibility. Sources familiar with Trump's legal operations told CNN that the January 22 rulings triggered immediate crisis within his legal teams. Attorneys across all cases held emergency conference calls throughout Wednesday evening, trying to determine how to respond. Some argue they should accept that immunity arguments are exhausted and pivot to fighting cases on the merits. Others insisted they should file emergency appeals to the Supreme Court seeking further clarification of the immunity framework. The fundamental problem is that the coordinated judicial response eliminated the forum shopping strategy that had been central to their approach. When every court reaches the same conclusion, there's nowhere left to shop. Smash that subscribe button so you never miss content like this. Here's what legal experts expect to see in the coming weeks. Trump's attorneys will almost certainly file emergency appeals seeking Supreme Court intervention. However, the Supreme Court rarely grants emergency relief when lower courts have uniformly applied Supreme Court precedent. The coordinated January 22 rulings actually make Supreme Court intervention less likely, not more, because they demonstrate that lower courts are faithfully applying the immunity framework. Meanwhile, trial courts in multiple cases are now moving forward with scheduling trial dates. The January 6 federal case could see a trial date set within weeks. The Georgia RICO case will proceed with pretrial motions. The E. Jean Carroll proceedings will continue toward final resolution. Court observers are watching to see whether Trump's legal teams can develop genuinely new strategies, or whether the January 22 coordination effectively ended the era of procedural delays. Closing final stakes. Here's where things stand right now. Trump's protective legal shield just shattered across 5 different courts in a single day. Judges appointed by presidents from both parties all rejected his immunity claims using identical reasoning. They cited his own public statements about delay strategies as evidence that his motions are filed in bad faith. His legal teams are scrambling to develop new approaches, while Trump publicly claims the coordinated rulings prove judicial conspiracy. Legal experts say this represents the definitive end of judicial hesitation. In cases involving Donald Trump, this isn't just another adverse ruling that will get appealed and delayed. This is 5 courts simultaneously closing off the procedural escape routes that prevented accountability for 3 years. The rulings are final on immunity. The judicial coordination is unmistakable. The patience of the courts has expired. Now Trump must face the reality that judges are no longer hesitating to reject his arguments and move his cases toward trial. What happens next will determine whether the American legal system can enforce equal justice. When defendants have the resources for unlimited litigation and the platform to claim that any adverse ruling proves the system is rigged, the stakes have never been higher. The coordinated judicial response has never been more definitive. And the collapse of Trump's legal shield has never been more complete. The legal landscape just shifted permanently, and there's no going back. Pause for a second and hit that like button if you found value in this coverage.